Yes, Your Honor.
Good afternoon, sir. Mr. Blanchard.
Yes, sir.
Good afternoon, sir.
Good afternoon.
And who's that with you at your table?
Ms. Partridge, she's helping with my paperwork.
All right. Mr. Mercer, what do you say? Is that okay with you?
Sure, Your Honor.
That's all right. Very well. We'll get started. You may be seated. This is in the Superior Court of Union County. This is Miller Blanchard, plaintiff, versus Lamar Paris, defendant. Mr. Blanchard did on January 11th, 2022, file a petition for writ of mandamus in this court, to which the defendant filed a response, timely, and subsequently did on February 3rd, 2022, file a motion to dismiss, which is what brings us to court this afternoon. What I'm going to do is let Mr. Mercer make a brief opening, and I'm going to allow Mr. Blanchard to do the same, and I'm going to allow Mr. Mercer to argue his motion. I'll allow Mr. Blanchard, of course, to respond. So that's the procedure we're going to use today. Mr. Mercer.
Thank you, Your Honor. Well, Your Honor, thank you for your time today.
Hold on a second, Mr. Mercer. Is there someone who can't hear what's going on here?
Right over here.
Miss Lodes reads lips. And such.
You can't hear Mr. Mercer?
Oh, yeah.
It was you, Your Honor. That's
All right. All right. Mr. Mercer, you may begin. Just a brief opening statement, please, sir.
Your Honor, before, my brief opening statement, very brief, is going to be, I'm going to show 3 grounds that this should be dismissed on: sovereign immunity, real party in interest, and problems with the actual writ of mandamus. Before I get into that, I know that Your Honor would like me to present first, and Mr. Blanchard has a chance to respond, but since it is my motion, I do have the right to go first and last. I would reserve to go last if that's okay with you, Your Honor.
Well, certainly you may. I mean, it is your motion, it is your burden.
And that way I'm not repetitive, Your Honor, and I'll let Mr. Blanchard make his opening statements and get right into his argument.
All right. Thank you. Mr. Blanchard, you're recognized.
Thank you, Your Honor. Do I understand that I should present now?
No, sir. This is your opportunity to make a brief opening statement, if you'd like, in response to the motion to dismiss. It's not a time for you to present evidence. It's just a time for you to tell me what you expect your opposition to these 3 grounds to be.
Understand, Your Honor. I'd like to state that it's clear that the plaintiff has standing. This was an issue. This is annotated in Title IX statutes as follows, where the question is one of public right and the object is to procure the enforcement of a public duty. No legal or special interest need be shown. It shall be sufficient that a plaintiff's interest in having the laws executed and the duty in question performed. This is well annotated in case law. As to the issue of immunity, this is a civil proceeding. No charges will come out of these proceedings. There will be no charges to have need for immunity. Immunity is a moot issue.
Why is immunity a moot issue?
There'll be nothing to defend, Your Honor, as I understand it, because there'll be no charges issued.
Well, that's not exactly right. The real issue is whether or not a sub-issue is whether or not the acts alleged to be unlawful or improper are discretionary or ministerial. That's one of the tests that the court has to look at. Discretionary or ministerial. Other thing the court has to look at, the other issue the court has to look at is whether the writ of mandamus is a proper remedy for addressing the issue that concerns you.
I can do that, Your Honor. These were addressed in the response to the motion to dismiss.
And Mr. Blanchard, I have read your response. I'm familiar with your response.
Okay, you're in agreement with the response?
No, I said I'm familiar with it. I'm not necessarily in agreement,
I'm sorry.
not opposed to it at this point. I'm listening.
Thank you.
I'm listening. But I think it's important to understand that a writ of mandamus is to compel a public official to perform a duty that that public official is required under law to perform, right?
That's my understanding, sir.
All right. And if I understand the facts correctly, your issue is whether or not Mr. Paris is correct in there was a road built here in Union County that was not, I think, according to what I understand, not competitively bid. Is that right?
That's correct.
That's what you allege.
Yes, Your Honor.
And the road's been built. Is that right?
Yes, Your Honor.
Money's been paid.
Yes.
All right. So what is the remedy? What are you looking to compel the defendant to do? Because to compel means it hasn't been done, right? That's what a mandamus is for.
Yes,
To compel. For example, let's just suppose a judge didn't perform some duty. You could file a writ of mandamus to say, Judge, you haven't done your duty. You need to act on this petition, on this lawsuit. So that's to force an act. One of the issues I have, and I want to hear from you on this, is how you address that in a writ of mandamus. There are other remedies that you can use after the fact. But a mandamus is normally, as I said, used to compel a public official to perform a duty.
Understand, Your Honor, I'm after future uses of the Title 32 and Title 36 OCGAs. And that was my impetus to file the writ.
And I understand
Future
that.
compliance.
I understand that. And I'm going to listen to your argument. I'm just telling you that that's something that concerns me about this vehicle. There are any number of vehicles you can use to get into court to address this issue. I'm going to listen to your argument on why this is the correct procedure to address this issue that concerns you.
I go back to the OCGA that you just referenced. This is 9624, where there is a question of public right. And this was addressed in case law with Rothschild.
Well, let me try to help you a little bit and narrow the issues a little bit for you, because there are a number of cases that distinguish between discretionary and ministerial duties. And discretionary acts in general, discretionary acts result in official immunity unless there's willful and wanton misconduct. On the other hand, ministerial duties are treated differently. So you have to look at what this duty was or is that the defendant had in paying out this contract. Was it a ministerial duty? Was it a discretionary duty? That's if you get past the notion, are you in court on the writ of mandamus? If you're in court on the writ of mandamus, then the court needs to look at this, what he did. Was it discretionary or was it ministerial? Because there is immunity that attaches to discretionary acts.
In my response, I addressed it as ministerial. The sole commissioner is the chief operating officer of the county, and it was is his duty to oversee his divisions, and this particular divisions let a project without bids or estimates.
All right, so let me help you with that. I'm going to tell you a little bit of what the law is. The single overriding factor for qualified immunity purposes is whether the specific act from which the alleged liability arises is discretionary or ministerial. In deciding whether an action by a public employee, like this defendant, is discretionary or ministerial, for purposes of entitlement to official immunity, the court must focus on the character of the specific actions taken by the government official or employee, not the general nature of the job, and the characterization is determined by the facts of each individual case, particularly the facts specifically relevant to the official's act or omission from which the alleged liability arises. Under this standard, it makes no difference that the official is required to perform discretionary acts if the complained of act is more properly characterized as ministerial. Now, the distinction, again, is the ministerial act, which is negligently performed, can remove a government employee's official immunity. That's a ministerial act. A ministerial act is commonly one that is simple, absolute, and definite, arising under conditions admitted or proved to exist and requiring merely the execution of a specific duty. For example, a school crossing guard who negligently allows a vehicle to enter a crosswalk. That would not be anything other than a ministerial act. There's no discretion involved in that act. It is an act which is simple, absolute, and definite. So I'm telling you that the issues the court has to look at, and what I've done in preparation for this hearing to try to help you and Mr. Mercer and anyone else who's here understand what the real issues are in this case.
I understand, Your Honor.
All right, thank you. Anything else you want to tell me?
Not at this time.
All right, thank you. Mr. Mercer.
Your Honor, I have prepared a brief in support of my motion. I know it doesn't look brief, it looks more like a novel, but it's just 14 pages and the rest is actually all the case law, the statutory codes, and the provisions of the Constitution that I printed out as to make an easier guideline to go along. I have a copy for everyone. May I approach?
Just hand it to the bailiff and provide Mr. Blanchard with a copy.
And Your Honor, this is just a rough outline so that everyone can follow along. This is my brief in support of my motion to dismiss. And Your Honor, what we're looking here today, I'm going to hit the sovereign immunity, I'm going to hit a real party in interest, and I'm going to hit the problems with mandamus. First, I'd like to look at some filings, some things that Mr. Blanchard put in his filings. In the case in hand, Mr. Blanchard has sued Mr. Parris as an individual for declaratory judgment to have the Union County government or the sole commissioner's office of Union County do the following as stated in Mr. Blanchard's petition. Now, this is a direct quote. Wherefore, Millard Blanchard respectfully requests that the court grant a hearing on this motion pursuant to Uniform Superior Court rules and require the defendant comply with the law as written in OCGA 32463 and OCGA 369122, thus preventing further unlawful taking of his and all taxpayers' tax money on all future projects requiring bids as annotated as referenced in the OCGAs. He filed this suit, of course, like you said earlier, in January 11th of 22. He tries to show the court his request is valid by pointing to a 2020 road project in which Mr. Blanchard claims that bids were not taken in violation of state law and a final invoice was paid in June of 2020. Mr. Blanchard further points out the Union County Road Department and their Union County purchasing policies and refers to Paris's knowledge of such. That will be important later. Mr. Blanchard claims that Mr. Paris has waived his sovereign immunity by committing a ministerial act. Mr. Blanchard shows his standing to the court by stating he's just a resident of Union County, and Mr. Paris, as an individual, is a resident of Union County. Mr. Blanchard further claims that damages are in excess of $15,000, in which the only way he backs those damages is the tax revenue that was used to build the road in question. Mr. Blanchard's reply to Mr. Paris's motion to dismiss, it does not mention any monetary damages that he has claimed in his petitions, but does state the following. This case is submitted in this writ as one example of multiple abuses of the OCGA's governing the bid process. This particular case is egregious in its entirety and was submitted to legitimize the need for the court's discretion on future bids ordered by the defendant.
It says the court's direction.
Yes.
It's the court's direction, not discretion.
I'm sorry if I misstated that.
The court's direction.
Thank you, Your Honor. I'm sorry if I misstated that. The writ of mandamus directing defendant Lamar Paris to comply with state law is needed and asked for. So now that I've kind of pointed out a few things, I first want to start with sovereign immunity. So sovereign immunity is annotated in the Georgia Constitution, Article 1, Section 2, Paragraph 9. Sovereign immunity and waiver thereof claims against the state and to its departments, agencies, officers, and employees. Section 8 says the General Assembly may waive the state's sovereign immunity from suit by enacting State Tort Claims Act, in which the General Assembly may provide by law for procedures for the making, handling, and disposition of actions or claims against the state and its departments, agencies, officers, and employees upon such terms and subject to such conditions and limitations as the General Assembly may provide.
Yeah, I don't believe that A or D, you have A and then C and then D.
I do, Your Honor. I pointed out the relevant parts to this, but I do in the full brief, I have the full constitutional amendment cited. I have the full thing actually printed out for everyone.
What I'm looking at is under D, where you begin, sovereign immunity protects all levels of governments from legal action. Now, in this case, we don't have we don't have Mr. Paris sued. Mr. Blanchard doesn't have him sued as the sole commissioner of Union County, does he?
That's one of the problems with this suit, Your Honor.
He's just sued as Lamar Paris, not in his capacity as the sole commissioner, right?
That is one of my contentions, Your Honor, yes. But that's not the relief he asks for.
I understand that. I'm just trying to see if he's got the real party and interest.
That, I am going to get to that, Your Honor. As Section D states, it does state, and I'll kind of be briefer on this since these are longer. Section C says that it can be waived for a contract, breach of a written contract. Section D states that tort claims of all officers, employees, departments are subject to suit may be liable for injuries and damage caused by negligent performance of or negligent failure to perform their ministerial functions. And they may be liable for injuries and damage if they act with actual malice or actual intent to cause injury in the performance of their official functions. Now,
I don't believe that was alleged, right?
Well, Your Honor, he sues Mr. Paris, asking for relief for the order against the government. He's saying that a governmental action took place. He's not going to allege that they have sovereign immunity, but as part of my motion to dismiss, as part of the privilege that all states and agencies and counties and governmental functions have, they have that privilege. And so first it has to be waived. It has to be waived, and it has to be waived by law, by statute. And if it is, then we have to see if there was the ministerial or discretionary function. This does apply to counties, Your Honor.
I understand that. I believe that to be true.
Okay. Now, according to the Constitution as cited, the General Assembly waived it for contracts. So if we look at Mr. Blanchard's petition to see, okay, is there a contract there that he has with the state or with Union County or with any party within Union County? He doesn't have a contract with Mr. Paris. He doesn't have a contract with the Union County government. He doesn't have a contract with the Union County Commissioner's Office. And he has not claimed that a contract has been broken that he has privity to. Okay, so one, you can't even imply there's a contract in his petition from how it's written or any of his replies, so that wouldn't stand. Now we have to look at, was there some sort of tort or negligent action committed against Mr. Blanchard that is specifically waived by law? Now those are held in OCGA 2120 through, OCGA 502120 through 502137. First, a tort by 5111 is the unlawful violation of a private legal right other than a mere breach of contract, express or implied. But a tort may also be a violation of public duty if, as a result of the violation, some special damage occurs to the individual. The special damage is the key phrase in that definition, which means Mr. Blanchard would have to have actual personal injury or actual damage to him from those actions, not just that he is a resident of the county. There has to be some sort of action that personally affected him for those special damages. If you further look under the state assembly or the general assemblies where they waive that, they define what a loss is. And that's under 502122 section 3. A loss means a personal injury, disease, death, damage to tangible property, including lost wages and economic loss to the person who suffered the injury, disease or death, pain and suffering, mental anguish, and any other element of actual damages recoverable in actions for negligence. So when looking to see if tort or negligence was committed against Mr. Blanchard, we have to look at what his personal damages were, and there's no personal damages alleged by Mr. Blanchard. Mr. Blanchard is not a contractor that builds roads. Mr. Blanchard has not claimed that he submitted a bid that was not taken. Mr. Blanchard has not had a bid rejected. He's not even submitted anything. Mr. Blanchard's claimed damages is that he's a resident and tax money was used to build a road in which he deems was violation of state law. That does not equate to personal injury or damage to himself. So we have to look at certain cases just to see where this was actually applied. We have Joyce versus Joyce versus Van Arsdale. This is where Marie Joyce brought suit against Emmanuel County to recover from property damage and personal injuries sustained when her car collided with a dismantled barricade in a county road. Now here, the plaintiff was personally injured by the action of the county. This is how she had standing to actually have the jurisdiction and waive immunity for the county. The court found in Joyce that, and this is pertinent to this case, in that case, they dismantled the barricade. She was caused injury by it. The court actually found that an employee who is exercising their discretion as to when and whether a street should be opened, closed, repaired, when a sewer should be built, or when a government employee is exercising a discretionary function of their duties, they will be immune for suit. If you're looking at Mr. Blanchard's petition, he says they built a road. Well, if you're pointing to Mr. Paris, well, as an individual, he doesn't have the authority to say we're going to build a road for the county. If you're pointing to him as sole commissioner, his only thing in there is, I approve this road being built, which falls right under here where Joyce says it's a discretionary function. We can further look at some other torts have applied. Milledgeville Water Company versus Fowler.
Let me ask you this, Mr. Mercer.
Yes, Your Honor.
There's some enabling legislation that establishes the sole commissioner form of government in Union County, Georgia, I take it.
Yes, Your Honor.
Does that legislation set out the specific duties of the sole commissioner?
The sole commissioner and board of commissioners, and I don't have that offhand. I'm sorry, I don't. But I believe they all have the same functions and duties, which one of the duties of a board or a sole commissioner is roads, road maintenance, stuff like that.
Well, it's to approve and let road maintenance contracts and road resurfacing contracts and take care of the roads in the county. I think that's right. I just thought it would be interesting to look at the specific legislation that established the sole commissioner form of government in Union County to tell me exactly what he's expected to do, because that could have a bearing on whether what he did was discretionary or ministerial. I mean, if it says the sole commissioner shall decide who's going to build a road and how much we're going to pay, then it clearly becomes non-discretionary, in my opinion.
Well, Your Honor, I don't have that offhand to quote you directly, and I apologize for that, but I don't believe in any legislation they allow. There's a bidding process for stuff over $100,000. There's an estimate process for certain things under certain amounts when it comes to roads. Those are two different processes, but any commissioner or commissioner board has the right to determine whether roads are built, maintained.
Well, and I think moreover, not only can a commissioner in general or a board of commissioners decide which roads are going to be built, but I think they have the discretion to decide who is going to be awarded the bid. And I know not always is the lowest bid taken, because the commissioner may have discretion, or commissioners, to determine that low bidder is not the best qualified person or company to perform the work. In that case, that would be a discretionary act. They would be acting in their discretion in determining that the low bidder was not necessarily the best bidder for the county, and there would be official immunity attached.
You are correct, Your Honor. The bidding process is there, and it is up to the commissioner to decide which bid to take. You are correct about that, Your Honor.
Well, just help me factually for a minute, because Mr. Blanchard seems to say that he's done some Open Records Act request, and that he received information that the road was built by Union County forces, and then he found more evidence that in fact the road had been built by a paving contractor or a road contractor and had not been built in-house. What's the truth of that?
There was a company doing dirt removal for the Tractor Supply, Your Honor. That company got contracted to haul dirt to other places. That company then got contracted to actually just grade a base out, and then the road department came through and paved and did all the other stuff. They did a partial part of it.
How much is their partial part worth on what Mr. Blanchard's concerned about?
Say that one more time.
You said that this company did a partial job on this road that was built, right? How much was that? How much were they paid for what they did?
He points to an invoice that is $130,000, Your Honor.
Right.
But if it made it past this motion, there would be evidence presented that would show that there were separate jobs, that it just got given to the county as one invoice by a private corporation.
I understand. Go ahead.
Your Honor, in Milledgeville, Water versus Fowler, Fowler brought suit against the Milledgeville Water Company to recover damages because he said the city had contracted to provide water to its citizens, and they were not providing it water. The one thing to bring out of that, Your Honor, is that the court found that there was no contract between the citizen and the actual water company, so he couldn't sue on that. And they did point out that if a tort was going to be waived for somehow to actually pierce sovereign immunity, it had to be wrongfully committed upon the person or property independent of contract. And I think that's important, Your Honor. They say it's a direct invasion of some legal right to the individual. It is an infraction. Number two, it's an infraction of some public duty in which special damages occurs to the individual. Or it's a violation of some private obligation by which damage accrues. Can't speak this today, Your Honor, I'm sorry. To the individual. In the first, there's no special damages. But if you look at number two and number three, which right here, if it was supposed to be waived, there has to be some public duty with special damage to this individual. There has to be special damages proved, which there's none even alleged here. An easy one for Mr. Blanchard's understanding and anyone's understanding is Mcconnell versus the Department of Labor. And that's where an employee of the Department of Labor sent out personal information of 1,000 Georgians to about 4,000 different Georgians. That there, because they are, sending and receiving emails, they sent people's personal information to people that shouldn't have had it. And that was a ministerial act that they committed, and sovereign immunity did not apply there. If we look at White versus the City of Atlanta, White sued the City of Atlanta in tort for damages arising from an incomplete and defective renovation construction of his home by a contractor under an improvement grant. The court found that there was no independent duty arising to White from the contractual relationship between White and the city, and he had no privity of contract actually with the city and the construction company, even though the city paid for a lot of his renovation. And even if the renovation was faulty, that did not end up committing a tort against White. White further argued that there was no exercise in due care in distributing the grant funds, and so with the decision to distribute those funds, the city advanced the funds to the contractor, and his remedy, because those funds were submitted to someone else, that now his remedy would be a contract, but he didn't sue in contract. And so just because it was on his behalf, the contract would have to be on his behalf directly, not as a taxpayer. And they went on to say that the city's activity in distributing the money itself did not extend beyond a conventional construction financing authority. And so therefore, White could not have a tort that would actually pierce sovereign immunity. In Gilbert versus Richardson, this is actually a case that Mr. Blanchard cites in his response. There was a car accident where a sheriff's officer struck another car on an emergency call. And the court found that the county had waived its portion of immunity to the litigant because they bought liability insurance for car accidents for their employees. So that was a waiver for that. But then when they looked at the individual, they found that the law enforcement officer rushing to back up an officer in response to an emergency call, that's a discretionary act. And so she has immunity for that. In Gwinnett versus Ashby, Miss Ashby was walking near some bleachers in a public recreation center. A drain cover was not on. She fell down and received some injuries there. She claimed that the fall was a result of the defendants negligently maintaining and repairing the drain and failing to warn of the dangerous condition. Of course, the county moved to have it dismissed, and the plaintiff responded saying they waived that dismissal just because there's the Georgia Recreational Property Act. But the court denied that there was any immunity waived because, again, immunity has to be specifically waived by statute for it to apply, for you to actually pierce it. The court went further to say, and I think this is pertinent here, that the party seeking the waiver of sovereign immunity has the burden of proof. And so they have to sit and prove that you're not entitled to sovereign immunity. And they don't have to file a petition that says they're not entitled to sovereign immunity. If I bring it up and I say, no, we have sovereign immunity, it's on the petitioner to prove that it was waived. And I don't see anything in here in any responses or pleadings to actually show that. Mr. Blanchard has not showed any personal injury or damage to himself to have actually waived immunity in this case. Mr. Blanchard claims that Paris has waived his sovereign immunity by committing a ministerial act. But in Joyce versus Arundel, they specifically found that when you're talking about the discretion to open, close, repair, whatever on a street, that's a discretionary act and is not a ministerial act. Your Honor, White even further shows us that a contract with the county with another entity to do work for a plaintiff is not even enough to have privity contract or a tort to waive that immunity. So even any contract between the county and someone to come do a little work on a road, that's not going to be enough for Mr. Blanchard to actually pierce the immunity, because he doesn't have privity to that, and he doesn't have any special damages. He's not claimed or shown any actual damages to himself as required by law, and he's not carried his burden of proof showing that the immunity has been waived. Your Honor, furthermore, if you have to look into sovereign immunity, under 50-21-25B, it says a person bringing an action against the state under the provisions of this article must name as a party defendant only the state government entity for which the state officer or employee was acting, and shall not name the state officer or employee individually. In the event that the state officer or employee is individually named for an act or omission for which the state is liable under this act, the state government entity for which the state officer or employee was acting must be substituted as the party defendant. Here, Blanchard claims negligent acts by Paris in his filings, which would mean that the respondent has committed some tort or breach of contract. Mr. Blanchard has named Lamar Paris as an individual, but wants actions from the court that are directed to Union County or the sole commissioner's office of Union County.
Well, that, as I said earlier, that's a concern.
Yes. Blanchard has not followed the law because he has refused to name the Union County government or the commissioner's office of Union County. And by doing that, just by this law alone, we have to dismiss this. Now, I'm going to skip over this part. There was some legislation, an amendment to the new Constitution. I'm going to be very brief. I'm not going to read over. Even Mr. Blanchard says it doesn't apply. I felt that I needed to talk about it because he's asking for a declaratory judgment, which is allowed here. And he's asking for it based off of, he wants a declaratory judgment to say you have to follow the law. Under the amendment to the Constitution, one, it had to be for any act starting January 1st, 2021 or further. An act meaning a legislative act, not a doing of an act, a legislative act meaning a law. It is designed to say this law is unconstitutional after January 1st, 2021, if such law was enacted by a county government or state. And it gives the petitioner, all they have to be is a citizen of Georgia or that county to say this law is unconstitutional, that was created after this date, and the Superior Court has the right to enjoin or block that law. That's what that was for. I felt because of some of his filings, I had some of the things in his filings I needed just to address that. But of course here, this is an act that's claimed in 2020. There's no claim that there's some unconstitutional law. Again, as far as sovereign immunity is concerned, Mr. Blanchard has not carried his burden of proof to show that immunity has been waived in any fashion. And this needs to be dismissed with prejudice. Now, the real party in interest. The petitioner has not named, oh, I'm sorry, if I could back up 1 second. Even under the new Constitution, it says, even if you want to sue an individual, you have to do it in the state's name. You got to do it in the state's name. You can't just say, here's an individual. You have to name the Union County government for their law. You have to name the commissioner's office of Union County. You just can't say Lamar Paris. Now that we get to the real party in interest in this, Mr. Blanchard, in my opinion, is clearly not named the real party in interest in this case and has failed to join the proper party under 911-12B7. Under OCGA 911-17A, provides in pertinent part that every action shall be prosecuted in the name of the real party in interest. No action shall be dismissed on the ground that is not prosecuted in the name of the real party in interest until a reasonable time has been allowed for objection for ratification of commencement of the action by or joinder or substitution of the real party in interest. Now, the controlling case over this is Dover Realty versus Butts County. And here, this was over Butts County tax assessors. It was over a tax appeal where some people filed a tax appeal in their personal capacity, not in their corporate capacity. And meaning that the land was actually owned in the corporate capacity, but the individuals asked for the, filed with the tax assessment their appeal in their personal capacity. Now, there's been long-standing rule here in the United States of America that there's always a difference between an individual, a corporation, and a government entity. You have three separate entities there. The court in Dover found that OCGA 91117A provides a reasonable time after objection to substitute parties or to take other corrective action therein authorized to avoid dismissal of suit. Now, they found that in that case, the motion to dismiss had actually stated the objection. In this suit, I stated that not only as an affirmative defense, but in the motion to dismiss. In Dover, their objection coming through the motion to dismiss that they were not the real parties in interest was filed on April 4th, 1991. It constituted an objection within the meaning of the statute. And an order dismissing that suit was not signed until June 27th of 91. Notwithstanding the lapse of the reasonable time between the motion to dismiss and the order granting said motion, they said the record does not reflect that the appellates timely initiated any corrective action as the statute authorizes. In this case, I think Mr. Blanchard may seem confused if I'm looking at it in the most positive light to him about what capacity he wants to sue in. If we have to look at his filings, Mr. Blanchard states Lamar Paris in the heading of this suit, which indicates an individual capacity. Your Honor, there's no asterisks by these headings. This heading is what the clerk has to put in the system. That's what everyone searches for and looks for, and it just says Lamar Paris. Now, the heading is not definitive as who the party is, but it definitely gives us a clear indication of what they are meaning to do. Blanchard also states that Paris is a Union County resident, which indicates individual capacity. Mr. Blanchard asked for relief in the capacity of the Union County government, but asked that the defendant be ordered to do so. Again, the named defendant is Lamar Paris, which indicates an individual capacity. Mr. Blanchard sometimes refers to Paris as the sole commissioner of Union County, but not in any portions of his pleadings where it's more definitive, such as any jurisdictional claims, venue claims, or party portions. And I'm saying this, and I keep pointing back to the heading because there's no asterisks in that heading where people's name is to say, to really know what I'm talking about, look at paragraph 5, section 6 of this pleading. This is where you name the parties. And of course, the proper party has not been named. Now, Your Honor, anything that Mr. Blanchard further cites in his claims is that an order of the court is needed, but that order, of course, has to be towards the Union County government or the Commissioner's Office of Union County, because the individual has no standing to actually do anything. It has to be with the government entity of what we're talking about. He does cite the Union County government departments and some purchasing policies, which that may point he's referring to the actual state office. But again, he's pointed to way more individual capacity elements than anything else in his petition. And so, again, the relief sought cannot be sought against the individual as named. It has to be sought and can only be applied to a government entity. I don't think this court has this court can do anything with it, anything that it wants, but an order from this court to say, all right, you as an individual, you have to follow this law. We don't allow suits that just ask for that, unless there's something pertinent going on to say right now this person is committing this act in which I need a declaratory judgment for it to stop. The pertinent part of that being the act is being committed right then. There's nothing here claiming that. The only claim of an act committed is back in June 2020. And again, even if you went for that, Lamar Paris as the individual doesn't have a capacity to make those decisions. It has to be the government entity, in which this is why this party has not been named correctly. Now, in my answer, or in Paris's answer, we objected to the real party in interest not being filed on January 26, 22. And our motion to dismiss, we claimed he was not the proper party, and that's in February 3rd of 2022. And by this date, Mr. Blanchard has not attempted to add the real party in interest to his petition. So it started in January 26th and February 23rd. We're now in September. He's had plenty of time to actually add the real party in interest. He has not, and because of that, this has to be dismissed. And finally, Your Honor, he's failed to state a claim on which relief can be granted. And that actually falls under OCGA 91112B6. Now, he's filed a writ of mandamus, and for it to be properly issued, there has to be no other adequate legal remedy to effectuate the relief sought. And the applicant has to have a clear legal right to that relief. Now, if you look under the mandamus sections, 9621, OCGA 9621, actually talks about how mandamus can apply to public roads. And if you look under OCGA 9621, it basically says, in short form, that the roads are not in repair for anyone to actually drive over them with a normal load. And that the county is not, or the state, or whoever has jurisdiction over that road, is actually not keeping their public duty by maintaining those roads. And so you can have a right to sue over the public roads. That's codified just right in the statute. In Mr. Blanchard's petitions, he's not claiming that the public roads of Union County are out of repair, that they do not measure up to the standards of roads for Georgia, and that they do not conform to the legal requirements as prescribed by law, and are in such condition that ordinary loads with ordinary ease cannot be hauled over such public roads. Because of that, his mandamus cannot issue. Also under OCGA 9621, mandamus shall not lie as a private remedy between individuals to enforce private rights, nor to a public officer who has an absolute discretion to act or not to act unless there's a gross abuse of such discretion. Now, Mr. Blanchard keeps referring to Lamar Paris as an individual. In multiple different forms in his petition, he's named him as an individual. And since he's named him as an individual in that individual capacity, his relief sought it's not towards a government entity like I've been screaming this whole time. Under OCGA 921, he cannot even bring a mandamus and name Lamar Paris. He has to name a government entity. That's the statute. If you look at OCGA 9626, mandamus will not be granted when it is manifest that the writ would, for any cause, be fruitless, nor would it be granted on the mere suspicion or fear before a refusal to act or the doing of a wrongful act is committed. Now, in Blanchard's reply to my motion to dismiss, he states, and I'm repeating myself, the case submitted in this writ is submitted as one example of multiple abuses of the OCGA's governing the bid process. This particular case is egregious in its entirety and was submitted to legitimize the need for the court's direction on future bids, ordered by the defendant. A writ of mandamus directing defendant Lamar Paris to comply with state law is needed and asked for. By his own words, the road's already built, so a mandamus would be fruitless. By his own words, this is for direction for future bidding processes, which is asking the court to grant a mandamus out of mere suspicion or fear that something might happen in the future, which is not allowed under the statutory law. Because of all this, his case must be dismissed with prejudice. Now, also, multiple cases, mandamus is not the proper remedy to compel the undoing of acts already done. Hilton Construction Company versus Rockdale. Hilton's bid was not taken by a Board of Education in Rockdale County. The court upheld, and I'm quoting the court here, mandamus is not the proper remedy to compel the undoing of acts already done or the correction of wrongs already perpetrated. Period, done. Here you have one thing purported to happen in June of 2020. This was not even filed until January of 2022. You cannot use a mandamus to undo acts already done. Dismissed. Atlanta Independent School System versus Lane. Here's where there was an agreement between two governmental entities to share taxes of their different sections of where they get tax money. Lane brought suit challenging the validity of this agreement and also seeking mandamus relief as to the repayments of amount previously paid thereunder. Court says mandamus should be denied when it would prove unveiling and when no result would be accomplished or the status changed by its issuance. Meaning, what's done is done. You can't go in past with a mandamus. You cannot change what's been done with a mandamus. The court also found that mandamus relief would not lie to compel the undoing of acts already done, and this is so even though the action was taken in this case was clearly illegal. It follows that the trial court did not err in refusing to grant the mandamus, compelling the system to pay back the funds it previously received under the agreement with the city. And then in Speedway Grading Corporation versus Barrow County, here the company Speedway bought a landfill in 1980. They subsequently bought about 8 more tracts that expanded that landfill all the way to January 1982. Barrow County enacted a zoning ordinance in December of '82 and zoned that property that Speedway had bought as residential and not agricultural. In '85, Speedway received a permit from the EPD to expand that landfill. And in '87, the neighbors that owned land beside Speedway sued to stop Speedway from expanding. So now you know that time frame. This is what the court found. Mandamus is not an appropriate remedy to compel the undoing of acts already done or to compel the exercise of official discretion. What Blanchard alleges has happened, and what Mr. Blanchard asked relief for, would be to do acts that allegedly were done, and because of that, he fails to state a claim upon which relief can be granted. Mr. Blanchard has named Mr. Parris for relief sought, but again, that type of remedy has to be against a government entity. Mandamus against an individual is not allowed. Mr. Blanchard cites alleged damages for tax money expenditures for the building of a public road in June 2020. This was filed in June 2022. Mandamus cannot be used for past actions. Mr. Blanchard wants a declaratory judgment for any future acts that may happen, but mandamus cannot issue out of suspicion or fear alone. And Your Honor, for all these reasons, this petition must be dismissed with prejudice. Thank you for your time.
Okay. Mr. Blanchard, I'll hear from you, sir.
Thank you, Your Honor. That was a long trip. Some of the case law to me did not apply. However, that's my judgment. I'd like to address the ministerial comments that Mr. Mercer came up with. It's my engineering, my background's engineering, I'm to the point and succinct. There's a North Georgia News article some time ago whereby the sole commissioner was questioning himself about projects and bidding. I'd like to.
Objection, Your Honor. This actually tries to get into the evidence of the petition itself and is not relevant to the motion to dismiss.
I'm trying to help you with that, Mr. Blanchard. The motion to dismiss is predicated on three separate and distinct grounds. What I need for you to do is address those grounds, if you would, and tell me how they apply to your cause of action. Number one. And number two, for you to tell me what a newspaper said would not necessarily be relevant, nor would it not be hearsay, because I don't have that evidence before me, right?
That's correct, Your Honor, I do not have copies.
Let's try to stick to, if you would, and I'm going to give you leeway. You're not an attorney, you're a lay person. I'm going to give you leeway, but if you would, let's try to stick to the three prongs of defense that Mr. Mercer has set out relative to your complaint.
Thank you, Your Honor. I was addressing ministerial.
Yes, sir, and that's something we need to address.
Right. Let me go to the previous statement I made then, and to the fact that the sole commissioner is the chief executive officer of the county. He's responsible, and he is also responsible for the ordinances and policies of the county. He has to sign them. So he obviously knows what the purchasing and bidding policies are. That's why I say that it's ministerial. And the comment that I would have offered was that he acknowledged that. So yes, I see that it is ministerial, and therefore he has waived his immunity. I would like to address the issue of the named individual. The first paragraph of the writ states that the defendant is sole commissioner Lamar Parris of Union County, Georgia. Parens Paris, close parens Paris.
But he's not sued in that capacity.
And furthermore,
Mr. Blanchard?
I understand, sir.
You understand that that's an issue.
That's a technical issue that I did not understand.
And I appreciate that. You're a layperson. And the typical layperson would not understand that you have to bring suit in the capacity which is alleged in the complaint.
Yeah.
So you've got an inconsistency that could well be fatal to you, to your complaint.
I understand that I did not input that important information in the upper left borders of the writ. But Your Honor, he was correctly named throughout the writ. It's my understanding in standard legal briefs, parentheses defines what that person is throughout.
The critical point is, in what capacity is he sued? And he's been sued as Lamar Parris. Not as Lamar Parris, sole commissioner of Union County, Georgia.
I understand that.
Therein lies the difference and the distinction.
And my intent doesn't count, but
I have to look at what the law is, Mr. Blanchard. And I think you know that and you appreciate that.
I understand. As far as standing is concerned, I was clear on that in the mandamus. I think one of the basis of standing is that I'm a citizen and taxpayer of Union County. And, that is where I have asked for the relief. There are other issues with, the bidding and estimating process. And my intent was to have an order whereby there would be bids and estimates for future projects.
I think what you just said is important for future projects.
Absolutely, sir. And that was always my intent. You can't go back and unring the bell. I understand that. So that was the intent there, and the relief, of course, was to have competitive bidding, for instance, relief for the taxpayers of Union County. So,
And you see what's happening, Mr. Blanchard, is Mr. Paris, in his capacity as the sole commissioner of Union County, is using his discretion in awarding these bids. You want competitive bidding. You want to see a bidding process that's transparent. I understand that.
yes, Your Honor.
That's not the form of government that you have in Union County. Not that it's not transparent, but you have a sole commissioner. And with that sole commissioner goes a lot of discretion. I dare say, and I'm not paid by Union County in any way, but if I wanted something from Union County, if I wanted a new laptop, because I'm a judge in Union County, and they know the circuit, not just in Union County, I guess I'd have to make application to someone in Mr. Paris's office, and then they would have the discretion to say, Judge Cornwell, you can have a computer for $600, or you can have a computer for $1,000, or you're not getting a computer. I think with that job goes a lot of discretion, a lot of.
I agree, Your Honor.
I might have to ask for a new microphone here.
I'm doing fine. I have my hearing aids up. I agree with you, sir, that the commissioners do have the discretionary choice of who wins a bid and who does not. However, I don't agree that in this instance and others, that it was not ministerial on the sole commissioner's part to not let bids. And that is the point of my writ. Projects are being done without bids. And that is ministerial because. the
Objection, Your
commissioner-
Honor. I'm gonna object to the statement that projects are being done without bids. That's speculative. That points right back to the code sections I've actually cited, that you can't even have a mandamus on suspicion or fear. It's just this suspicion or fear that this is happening. He has no proof that it's happening.
All right, thank you. Go ahead.
One of the elements of pleading this case is to prove that the OCGAs were abused. And that's what I had intended to do with this case, using the Mountain View Connector Road.
All right, and let me help you with that. When you tell me the OCGAs, which stands for the Official Code of Georgia, annotated,
Yeah.
it is, I'm trying to remember how many volumes we have now. Many volumes in that code. And of course, the annotations are the cases that apply to that code. Back when I was a young lawyer, you would look up the statute, and then you would look up the cases that followed that statute, those being the annotations, to see what cases apply to that statute. And at the end of every year, they give you a paperback book to put in the back of the hardbound book for the updates. Well, now it's all on your laptop. But when you say that the OCGAs, that's a lot. You know, if you're in court again, say Judge Cornwell, it's OCGA 9-11-56. That's the motion for summary judgment. That's the vehicle that brings us into court today. So when you say the OCGAs, that's not helpful to me. And I can't go search those out, ferret those out. And I think you understand that.
I had stated previously that it was titles 32 and 36. And I've got the subsections of them as well, and would use that in closing. It is not OCGA's.
All right, thank you.
I think that I have addressed the 3 points that Mr. Mercer brought up.
All right, thank you, sir. Mr. Mercer, anything else from your side, sir?
Your Honor, since I do have the right to go last on my motion, I'll be very, very, very brief, unlike my original presentation. Just because an act is ministerial, I want this to be clear on the record, just because the act is ministerial, that in itself does not waive sovereign immunity. There has to be an injury caused from that ministerial act. I don't agree that what the Union County was claimed to do in 2020 was a ministerial act. It's a discretionary act. But even if it was, it has to damage Mr. Blanchard personally. And I went over many cases on how that can happen. As far as a real party in interest, Your Honor, I actually laid out the multiple times he was claimed as an individual and the times it got claimed for and the relief sought for an actual government entity. There's way more individual capacity than a governmental capacity. And that's going to stop you under sovereign immunity, that's going to stop you under real party in interest, and that's going to stop you under a writ of mandamus. All 3 of them, because you haven't named the government, you want to name the person, not the government, is going to stop you under all 3. And that's not even, I don't have to go look for specific cases like the court was discussing earlier. I can look in the OCGAs right there in bold print that says it on all 3 of them. And as far as a mandamus, Your Honor, and I think you were trying to get this point across to Mr. Blanchard, is that he even admits, why, I just want this for future projects. You cannot do that. You cannot sue someone under suspicion or fear. And it doesn't matter if you point to something that happened in the past, because you're not allowed to sue under mandamus for past actions. Either way you look at this, Your Honor, this needs to be dismissed, and considering all of the information I included today, even under sovereign immunity, even if the right party was named, this could not go forward. Even under a mandamus, if the right party was named, this could not go forward. Even the real party in interest dismisses it on its own. But even if he actually applied the Union County government or the Commissioner's Office of Union County, it still would be dismissed under sovereign immunity and the problems with mandamus as applied to these facts. And Your Honor, naming Lamar Paris as sole commissioner, what point would an order, here's why that's fruitless. Saying Lamar Paris as sole commissioner is ordered to do this. What happens if he doesn't run again? What happens when you have a new commissioner? That doesn't apparently apply to them, because it's Lamar Paris as sole commissioner. If you're looking for a declaratory relief towards a government, you name the government. You name the specific office, the Union County Road Department, Union County Sheriff's Office, Union County whatever, because it is fruitless to name the individual unless that individual actually broke a contract with you or committed a tort against you personally. That is the only time they're being named, but in there you are asking for immediate damages caused by your personal injury. That's where that's appropriate. In any other time where you want declaratory relief, you got to name the government. And even in naming, even if he would have named Lamar Paris as sole commissioner, I would have the same argument, because what happens to that order when Mr. Paris is no longer commissioner? It would not apply. Again, it would be fruitless. And so, Your Honor, thank you for your time.
I want to make a couple of comments before I tell you how I'm going to rule on this case. Back when I was practicing law, I got into an issue with the government of Stevens County. And my client was building a subdivision, and the county was trying to abandon a road in the subdivision because to maintain the road would have been, in the county's words, prohibitively expensive. So I filed a writ of mandamus to compel the county to repair the road. We won at the trial level and lost on appeal. I guess the point of that is I know my way around the mandamus and how they work. Secondly, Mr. Blanchard, I guess I appreciate people like you who keep an eye on government. Government doesn't always get it right. We have to have people who are mindful of what government is. I don't know Mr. Paris. I don't think I've ever met Mr. Paris. I don't know if he's in this room or not. I just know that he's the sole commissioner of Union County. So I don't have any pushback whatsoever on you or someone else who lives here in Union County taking an active role in watching what government does. Now, addressing the merits of your petition. There's some cases that I have read in preparation for today's hearing, some legal research that of course I've done to further educate me on these issues. One case that I found instructive was Logue, spelled L-O-G-U-E, B. Wright, W-R-I-G-H-T. That's found at 260 Georgia 206. It's a 1990 case. This is dealing with the distinction between discretionary and ministerial acts, which is important. These are almost, Mr. Blanchard, law school sort of analysis and questions that you might expect to see on a bar exam. This case holds, that is Logue, we agree with the appellant that the distinction between discretionary and ministerial acts remains viable for county employees, as the Supreme Court recently ruled in Logue, that even if a county has not waived sovereign immunity by the purchase of insurance, a county employee nonetheless may be liable for the negligent performance of a ministerial act. Conversely, if the employee acted in his official capacity and the challenged act involved the performance of a discretionary duty, the employee is entitled to the defense of official immunity, provided that the act complained of was not malicious, willful, or corrupt, or done in reckless regard for the safety of others. I find in this case that Lamar Paris acted in his official capacity and that the challenged act involved the performance of a discretionary duty. I find that the act complained of was not malicious, willful, or corrupt, or done in a reckless disregard for the safety of others, and just parenthetically, that has not been alleged by Mr. Blanchard. Now, turning to the second issue. Lamar Paris is sued in this case by Mr. Blanchard individually and not as the sole commissioner of Union County. That is an issue because the relief sought involves Lamar Paris in his capacity as the sole commissioner. Because the case was not brought against Lamar Paris in his official capacity, he is not the real party in interest. Citing to OCGA 9-11-12 paren B paren 7 for that proposition. Finally, turning to the propriety of the writ. As I said earlier and gave you the example of the case that I was involved in, the purpose of a writ of mandamus is to compel a public employee to perform an act required resulting from that position as a public employee. I gave an example. If Mr. Blanchard had said, Judge Cornwell, I want to have a hearing on this case, set a hearing down, and I didn't do anything, I just said, I'm not interested in that case, I don't care, then Mr. Blanchard could certainly have filed a writ of mandamus against me to compel me to do that. I'm not encouraging you to do that, Mr. Blanchard, because I gave you a hearing on this case. But that's how you use a mandamus, to compel a future act. And it can't be used to put toothpaste back in the tube. It can't be used to undo an act that's already been done, nor can it be used to prevent an act that may have that you speculate may happen in the future. There is a remedy. There are remedies available to you and others in Union County if you take exception to what Commissioner Paris is doing. However, given this factual situation and the fact that the road has already been built, the money's already been spent, the writ of mandamus does not apply, and I can't afford you any relief under your petition. So, I don't have any choice in this case. I've given you my reasoning as to why you're not in court on this case. Those 3 reasons. Consequently, your petition is going to be dismissed as it stands for the reasons I've given you. I again say to you, and I hope you'll take this to heart, it's fine to be a watchdog. We need people to be watchdogs. I'm not critical of you as a person in any way for bringing this complaint. You have certainly presented your case well. You have not wasted the court's time. I've taken everything you've done very seriously. I have responded to your emails and your concerns, and you've done a good job. You're just not quite there on some technical issues. All right. But what Mr. Mercer will do is he'll draft an order based on my findings. He'll submit it to you to approval as to form, not substance. I'm not asking you to agree to the substance of the order, but simply to the form of the order. Then it'll be submitted to me in Word format. I'll take a look at it. I'll change things that if I think something's not appropriate or not accurate, and then I'll file an order on what's called Peach Court. So it'll be a public record of what's been done here today. All right? Mr. Mercer, any questions?
No, Your Honor.
Mr. Blanchard, any questions?
No, Your Honor.
All right, we're adjourned. Thank you.
Thank you, Your Honor.